All right, I think we are ready, so we are going to begin. Welcome and thank you everybody for joining us today. I'll let more people trickle in, but we are beginning so that we can respect the participants and the panelists' time. Before we start, I just wanted to go through some housekeeping for our Zoom. We are in a Zoom webinar today. If you have any questions or any quick comments, please use the chat. This is especially useful if you have any technical difficulties. I'll keep my eye out on the chat and fix anything as soon as I can. If you do have any questions about the presentation for our facilitator or our panelist, please use the Q&A. This will save the question for an appropriate time to answer. Finally, if you are joining in through Zoom, this is being presented in English and Spanish simultaneously. Go ahead and look at your Zoom options on the bottom right on the menu. Look for the gridded globe icon and choose the language of your preference, English or Spanish. If you are having any audio issues, make sure you mute original audio. And if you have any troubles with these functions, please let me know in the chat and I'll fix them for you. And that's it for me. I will go ahead and turn it over to Jennifer with Alpine Legal, and she'll present our panelist. Jennifer.
Thank you, Alex. Good evening, and thank you for joining us for another Know Your Rights webinar this evening. I am Jenny Wary, the Executive Director of Alpine Legal Services. We're pleased to be partnering with Colorado Mountain College, Garfield County Public Libraries, Basalt Regional Library, Pickens County Libraries, and Towards Justice this evening in order to share information about important legal rights at no charge to our community. I am pleased to introduce our presenter this evening, Natasha Viteri with Towards Justice. Natasha returns to Towards Justice after graduating from the University of Colorado Law School in May 2021. She's originally from Quito, Ecuador. In 2006, her family moved to Texas, where she attended the University of Texas at Austin and studied public health with a minor in social inequality, health, and policy. Natasha has also worked as a law clerk at Earth Justice, Towards Justice, and Bridge to Justice during her law school summers. As a third-year law student, she worked as a bilingual compliance investigator for the Colorado Department of Labor and Employment. Tonight, Natasha will discuss wage theft and recovering unpaid wages, discrimination and harassment, and ways employers can sometimes undermine a worker's ability to leave their jobs, including non-compete and no-poaching agreements, debt bondage, coercion, and human trafficking. Welcome, Natasha, and thank you for sharing this important information with us this evening.
Awesome. Thanks so much, Jennifer. Alex, I might need your help sharing the presentation, because now when I try to share, I don't even see the option for PowerPoint, which is very strange because I know I have it open.
You got it. Let me bring that up.
Yeah, let me try one more time, but that's weird because that just disappeared.
It has been a technical difficulty sort of day, so.
Oh, well, yeah, I feel that.
Okay, we are ready. If you can see the screen.
So that I know what I'm doing. Let me set up my second screen really quick too.
Perfect.
Okay, that way I can see you and make sure that we're on the right slide. All right.
Okay.
Okay, so.
Just give me an audio cue to switch to the slides.
Excellent, I will do that. Okay. All right, so hi everyone. Thank you so much for being here. Thank you for taking your time on a Wednesday night to share it with us. So I appreciate that. Welcome, as I said, my name is Natasha Viteri and I'm an attorney at Towards Justice out of Denver, Colorado. For those of you who don't know Towards Justice, we are a nonprofit legal organization that advocates for and collaborates with workers and workers' organizations to build power and advance economic justice. And sorry, Alex, I forgot to tell you to go to the next one. There we go. Thank you. So we're here because we cannot carry this work forward without you, and we really exist to carry these cases forward that really make an impact in the lives of our clients, and not only them, but also their coworkers and their industries. So for me, my hope after this presentation is that you know a little bit more about Towards Justice, about the work that we do to combat workplace injustices, and we really want to make sure that you feel comfortable reaching out to us if you have any sort of employment-related questions or problems. Ultimately, we really do believe that workers have inherent power, and we're just here to make sure that your power is defended and that you know what your rights are. But, you know, I want to also know why y'all are here. Is there any issue in particular that you're worried about? Do you feel powerless at your job? Or are you here just because you're curious about your rights? So we can just go ahead and jump in. Alex, you can go to the next one. Thank you. Great. So as I said, here at Towards Justice, we're here to help, and we want to make sure that you feel comfortable reaching out. We are attorneys, and we mostly litigate our cases in federal court, and we mostly focus on impact litigation. That just basically means cases that will affect a lot of different workers at once. However, we also have a pretty robust intake program, and this program is really special and important to us because this is how we find out what the labor landscape is like, right? This is how we find out what kind of labor abuses are happening out there. And in that sense, y'all are really our connection to what's happening on the ground. So again, if you remember just one thing from tonight, we want to make sure that you understand that Towards Justice offers not only free, but also confidential intakes. So all you have to do is go to our website, which is on the slide, as you can see, and you'll be able to fill out an intake form, which is available in both English and Spanish. So there you can give us a little bit of information on what's going on, and we'll be able to reach out to you with resources. As I said before, we are lawyers, but unfortunately, we really can't take every single case that comes through our doors. However, what we do try to do is direct you to the right place or the right agency, or we refer your case to our network of just really amazing employment attorneys that might be able to help you with your particular issue. Another thing I want to highlight is that immigration status does not matter when you come to us with an intake. In fact, we can help direct you to the right resources or help explain what your rights are as an undocumented worker. So please reach out. And we also have Spanish-speaking attorneys like myself and like Nina, who's also on the call. So again, if you have really specific questions about your situation, then please go ahead and fill out an intake form and we'll get back to you. Next. Awesome. So for today, I want to cover kind of three big topics. One of them is going to be wage theft and how we can recover unpaid wages. The next one is discrimination and harassment. And the last one, if we have time, is going to be ways in which employers make it much harder for you to leave your job. Next. Great. So you see a timeline here on the slide. And what I'd like to do is use this timeline to sort of orient ourselves during the presentation. So I want you to think about your rights at work on a timeline. So from the time you apply and you interview for a position, so that would be pre-employment, right? That would be the first kind of, that first part of the timeline there, to when you're hired and when you're performing your duties. So that would be the during employment phase in the middle. And then think about the end, when you're trying to leave your job, or if you want to quit or something like that, that would be leaving employment. So that'd be the end of the timeline. We're not going to talk about all of the topics that apply to each of these phases, but it really can be helpful to think about these rights in a timeline. And we're going to kind of figure out how to use this timeline to visualize when certain rights attach and when. So when we're thinking about pre-employment, think about, for example, when you're applying for a job and if you might face some sort of discrimination in the hiring process. You can also think of pre-employment as when you're applying and maybe you're misclassified. Maybe you're being told you're an independent contractor or as instead of an employee. So those kinds of issues come up more for that pre-employment side. During employment, so this is when most of your rights attach, and think about things like paid leave, like wage theft, discrimination, concerted activity, whistleblowing, workplace health and safety. So the majority of what we're going to talk about today is going to occur in that during employment phase. Okay. So as I said, most of the rights that we're going to talk about apply during that middle period. And that's when you're also more protected. And then that last phase, leaving employment. So that's another topic that we'll cover. So that'll be like the non-competes, the non-poaching agreements, debt bondage, coercion. And these are all mechanisms or tools that employers use to keep you stuck and working for them only. So again, these are going to be the ways in which employers make it harder for you to leave your job. And we'll talk about those today. We can go to the next slide. So I'd like to review some of the most common questions that we get from workers. And we get these questions not only through our intake program, but also during things like today, like a Know Your Rights presentation, or as we're speaking to other attorneys that work in the employment field. So let's look at some common scenarios. And as we're kind of thinking about these, I want you to ask yourself, what kind of issues do you deal with at work? Do you know where to go for help? Do you know how to try to resolve that if you can? Okay, next. All right. So let's start by talking about the most common issue that we see. And this one usually occurs once you've already been hired and once you've started your new job. So at this point, we're back to our timeline and we're in that during employment time. So this issue maybe presents itself on your first paycheck, or maybe you don't have an issue with this until years into employment. Or it might be that you've had this issue all along and you didn't know. Next slide. So let's look at the first scenario. And I'll just read it so that we can all hear it. I think my boss didn't pay me for all the hours worked. How can I be sure? And again, we get this all the time. So what do we call this issue? What name does it have? Next slide. Okay. So this is known as wage theft. And wage theft is probably our top category in what we see in intakes. And that's because it's really rampant, it's very prevalent, and lots of workers will deal with this during their time as a worker. Many people stay in jobs in which they're underpaid in hopes that they're going to recover any sort of lost wages. And the bad thing is that this vicious cycle keeps workers stuck in bad jobs where they're not treated right, and it really allows for ample abuse. Next slide. So what is wage theft, right? I'm sure you've heard about it, or maybe you've experienced it. So essentially, wage theft is the denial of a worker's right to their earned wages and benefits. And these wages and benefits are usually protected by either federal law or state law or local labor and employment laws. As I said, it's a big problem. Every year, over $750 million is stolen from Colorado workers. And this victimizes or it involves over 500,000 Colorado workers every year. And of course, this disproportionately affects immigrant workers, young workers, workers of color. So again, this is a big issue that we want to resolve. Next slide. So the tricky thing here is that wage theft can manifest in a lot of different ways. And I'll just name a few because maybe some of these, hit close to home, or maybe someone who's, experienced this in the past at a job. But a lot of really common examples of wage theft are going to include a failure to pay all time worked, or your overtime if you haven't been paid for that. Maybe there's a future promise to pay. So something that I hear from clients a lot is a boss saying, I don't have the money now, I haven't been paid, but I'll pay you next week, and then when you go and you ask them for the money, they'll say, well, I still don't have it, I'll pay you next week. So those future promises to pay are essentially wage theft as well. If your salaries don't add up, if you have a certain bonus structure or there's certain money that you're expecting and it's not happening, that's also going to be an example of wage theft. If you're not paid for paid leave that you're entitled to, if you're not being provided with the breaks that you deserve throughout the workday, if you're not being paid a minimum wage, if you're being charged for tools or uniforms. If you look at your paycheck, which we'll talk about in a little bit, but if you see that there's illegal deductions, if your boss is taking money out and you don't really understand why, that could also be a form of wage theft. Another really tragic example is, you're working for someone, you don't really have a ton of information on them, and then suddenly when they have to pay you, they disappear. You can't contact them, you don't have a good phone number, and they're essentially gone. Maybe that company never really existed. So that again is another form of wage theft. And the last one, I also want to talk about misclassification. So that essentially means that you are being told or you're being classified as an independent contractor rather than an employee. And that is a big form of wage theft because you are entitled to certain things such as like overtime and other sorts of, rest periods if you are an employee. So if you're being told that you're an independent contractor, you might be missing out on wages. Next slide. Okay, so I want to make sure that we all kind of know what we're entitled to and what we deserve and what our rights are and what things are not necessarily going to be, part of the law. So what are our rights under wage and hour laws? What are you protected against? What are you not protected against? It's important to understand that distinction. So simply put, your protections include minimum wage, meals and so rest and meal periods, so breaks, and then overtime pay. This is something that I want to touch on too that surprises people, but Colorado wage law does not require that vacation time be given. So you're not entitled necessarily to vacation time, and Colorado wage law does not require paid vacation and does not require that an employer establish a vacation policy. So an employer doesn't have to have one. However, and this is the important thing to keep in mind, an employer may establish a vacation policy. So they can set one up either in writing or by custom and practice. So if this is how things work, if this is how other employees do it, if this is how it's been done, then that would be more of custom or practice. Important also to keep in mind, employees must be made aware of the employer's policy. So they have to know about it. It can't be something that only a few employees know and not others. And employers and employees must follow this established policy unless that policy is changed. So if you do have a vacation policy in place, and if you're not being paid for it, so if you take vacation and they don't pay you, then you have a claim, and that vacation time would actually be wages and compensation that you're owed. So if you get fired or if you leave, you should be paid out for that vacation, if that makes sense. Another thing to keep in mind about holidays, Colorado wage law does not require, but it also doesn't prohibit any sort of paid holidays. And it also does not require you to be paid extra if you do work on a holiday. Another thing to highlight here, immigration status does not affect these protections. So if you are an undocumented worker, you are entitled to all of those things, to minimum wage, to breaks, maybe to overtime. So your employer might want to intimidate you and tell you that you're not entitled to those rights because you're undocumented, but that's not true. You still can claim those, you still can demand your wages. Next slide. So let's make sure that we're on the same page with the numbers. So what is minimum wage? And this changes annually, so it might be a little bit difficult to keep track. But for 2022, federally, the minimum wage is $7.25 an hour, okay? However, in Colorado, that minimum wage for 2022 is $12.56 per hour. And in addition to that, if you work in Denver, the minimum wage is $15.87 per hour, okay? If you are a tipped employee, and I will go into this in more detail in a little bit, but if you are a tipped employee, then you need to be making $9.54 an hour, and then you're also entitled to your tips. So we'll talk about what that means. In addition, it does not matter if you're paid by the hour or if you get a salary or piece rate or commission. It doesn't change what the minimum wage would be. However, if you do employ an unemancipated minor, I'm sorry, it's a hard one to say. If you hire an unemancipated minor, you can pay them 15% below the minimum wage. So that's one of the only scenarios really where you can pay less than the minimum wage. And also remember that there might be a state and local annual increase. So these numbers maybe and probably will be different for 2023 and beyond. Next slide. All right, so let's talk about breaks, because I think that this is something that people are often a little bit fuzzy about. So Colorado workers, and when I say that, I mean most Colorado workers. Not everyone will be entitled to breaks, but for the most part, most employees in Colorado are entitled to breaks. And you get two different types. So there's rest periods. So that's going to be a paid 10-minute break for every 4 hours that you work. Okay, so that's a rest break. And then you're also entitled to a meal break. And meal breaks are unpaid 30-minute duty-free meal periods during a shift of more than 5 hours. So we're going to break these down one by one. So for rest periods, employers must authorize and permit employees to take all required rest periods. Now, there's a little bit of funny language with this, talking about authorize and permit. So it's one thing for your boss to tell you that you can take a break, but does your boss actually let you take a break? So if you're still on call and if you're still having to do work during your break, then that might not be a break, right? Also to keep in mind, this doesn't mean that employees must actually have a rest period. If you choose to work during your break and you're not being pressured by your boss, then they're not going to have to pay you for those extra 10 minutes, right? So if you voluntarily skip a break, that's okay. Your boss will not get in trouble. But again, if you're being made to work during that break, that's a little bit different. And that's because rest periods, so these 10-minute breaks, are considered time worked for the purposes of calculating both minimum wage and overtime. So a rest period requires 10 minutes of pay without any work. So any work that you do during a rest period is more work. It's additional work and it'll require additional pay. So if your boss doesn't let you actually rest during these 10 minutes, then they owe you 10 minutes of wages. And I think this is something that people don't really, they don't really pay attention to, but that's why it's important to kind of keep track. Am I actually able to take this break? Am I not? And again, kind of keep that flagged in your mind. And then, as I said, there's the other type of break, which is your meal period. So employees should be entitled, and they should have an uninterrupted and duty-free meal period of at least 30 minutes. And that is going to be the case when your shift is more than 5 hours of work. So if possible, and this is, it's not a hard stop, but if possible, this meal period should be 1 hour after you start working, or an hour before the end of your shift. That might not be possible for every job. There might be some cases where you have to take your meal period a little early or right at the end of your shift. But for the most part, it should be, kind of after that first hour and before that last hour. Important also to keep in mind, for a meal period to really qualify as unpaid non-work time, employees must be completely relieved of all duties. You should be allowed to leave the work site, and you should be allowed to pursue personal activities. So for example, during my lunch break, I like to watch reality TV, and that's perfectly fine. It's my meal period, right? Other people might want to go run an errand, or they might want to, exercise or do things like that. You must be able to pursue personal activities during that 30-minute break. If you work in a business, or if you work in an industry where it's really hard for you to get a 30-minute kind of like uninterrupted break, then you probably should get paid for those 30 minutes, okay? Employees should be permitted to fully consume a meal and of their choice. So if your boss brings in pizza, for example, and forces you to eat that, that's not going to necessarily be a meal break, right? You basically should be fully compensated for any on-duty meal period without any loss of time or compensation. So I know it's a lot, but the big takeaway here about breaks is that if you're working, then you should be paid and you deserve to be paid. So keep that in mind as you're kind of figuring out what your breaks are and if you really have been compensated correctly. Next slide. All right. I get a lot of questions about how people can watch out for wage theft, right? How can I avoid that happening to me? I really like to recommend that people keep a really good set of records. That's going to be so helpful, especially if you decide to go to an attorney at some point, or if you want to go to the Department of Labor. It's going to be a good idea to have records. Also, because you don't want to rely on your boss or on your job to accurately keep track of your hours. They might not have the best systems to keep that. They might not have policies, that really keep a good track of that, or they might want to cheat you out of your money. So it's really important for you to keep track of your own hours. So once you start a job, you want to make sure that you keep track of all the locations of your job sites. So maybe you're a housekeeper at a hotel and you work at different types of hotels, right? You want to keep track of when you were at each location. And in addition, you want to also keep track of your hours. So when did you get to work? When did you leave? How long did you take for lunch? Were you actually able to eat? Things like that. And your 10-minute rest periods as well, because those can turn into wages if you're not actually getting them. Next slide. All right, so another common scenario that we see in our intakes is that people might feel like their paycheck doesn't add up. So you have a certain amount of hours that you worked and your rate of pay, and that makes sense, right? Your gross pay. But then once you see your net pay, you see that they've really taken out a lot of stuff. And you might wonder, what is legal? What is illegal? What are they allowed to take out? And how do they need to kind of communicate to me that they've taken that out? Next slide. So there's a lot on here because this is a little bit tricky. There's a lot of different things that kind of go into deductions and credits. And I'm just going to kind of briefly touch on this. But I really encourage everyone to look at your paycheck next time. Every time you get it, look at it and see what they're taking things out for. So as I said, this slide is going to cover the subtractions. So those are deductions, things taken out, right? And these are deductions that employers, can and cannot make from wages. And we're also going to talk about when employers can treat certain amounts or certain things they give to you as credits. So a credit is basically a way for an employer to subtract from your hourly rate from minimum wage. So I'll explain that in a second. Important to also remember, deductions and credits are both ways in which employers can reduce your wages, and they just work a little differently. So let me give you some examples to make that a little clearer. So for example, an employee earns $100, right? So you make $100 and your employer takes out $10 for taxes. So your employer deducted $10, okay? So that's a deduction. However, let's say that you work at a restaurant and you make tips, right? Because you make tips, your employer can take a credit of $3.02 per hour to offset the wages that it has to pay you. And that's because they're depending on you also making tips to be able to bring it up to minimum wage. That is going to be called the tipped minimum wage. And that's why the tipped minimum wage is lower than the regular one. It's because they can take this credit and they kind of, depend on you making tips too. I have a whole nother slide about tipped minimum wage. What I want you to remember is that you should be making minimum wage every hour anyway. So if it's a slow day at the restaurant, if you're not getting a ton of tips, your employer needs to bring you up to minimum wage. Okay. So the Colorado Wage Act prohibits and does not allow employers to take money out of your paychecks. So they can't deduct except in certain cases. And they also have to show that they are allowed to take that deduction. So the burden is on the employer. They also, in addition to that, have to itemize the amount and the reason for all deductions and credits. So that's why I'm telling you, look at your paychecks, make sure that it's right, because they have to put all of that on there. So for deductions, we've got, as you can see on the slide, a couple of categories. So we have things that are required, and these might be more familiar. So when I look at my paycheck, they take out taxes, they take out FICA, they take out Medicare, Social Security. So those are all kind of regular things that you'll see deducted from your paycheck. There's also things like garnishments and other court-related deductions. So let's say that you owe the IRS money, they can take from your paycheck to be able to pay back what you owe. And then the last one that could be required or allowed by law are automatic enrollment and employee retirement plans. So if you have a retirement plan, your employer can automatically take that out and deduct it every paycheck. The next category that we'll see here are deductions with a written agreement. So these deductions can only be taken out if you have a written agreement with your boss. So this will include things like if your boss gave you a loan, if there was some sort of payday advance, if they overpaid you last pay period, they can take it out of your next one. If they provided you with goods or services, equipment, property, all of those can be taken out, but there's certain conditions. So the employer has to have the employee's written agreement to make that deduction. That agreement that you sign has to be enforceable and lawful. The deduction that they do take out of your paycheck cannot bring you below minimum wage. So you can't be making less than minimum wage after they take it out. And these deductions really must be for the employee's benefit and not just to kind of cover the employer's cost of doing business. So they can't, kind of put that cost on you. It really must be for the benefit of the employee. And then there's also a category of deductions that are not allowed. So impermissible deductions. And things like that are going to be, for example, if your employer thinks that you cost them a client, so you lost a deal, they can't take that out of your paycheck because you lost the deal. If you don't do the work the way your boss likes it, or if they're not satisfied with your job, they can't take that out of your paycheck either. If you were fired or if you did not give 2 weeks notice when you quit, they can't take money out from that. And then if you used company property for personal use, and if you caused any sort of wear and tear, maybe in a vehicle or on other property, they can't take that out either. Now, that doesn't mean they can't come after you for that kind of thing, but they're going to have to use a different avenue to be able to pursue that money. Okay, so those are deductions, right? I want to briefly touch on credits because it might not be, we talked about tips, but it might not be as common for most people. But there's only 3 allowable credits. So there's really only 3 scenarios in which an employer can take a credit towards your minimum wage. One of them is going to be lodging credits for employer-related housing. And the thing about that is the credit that the employer takes really can't be more than the housing's fair market value or the actual reasonable and the reasonable cost of providing that. So essentially, the rule is that they can't be making money off of you if they're using that as a credit towards your wages. Okay. With housing, this can get tricky too. If you're being forced into a specific house and you don't have a choice, then they really can't take a credit for that either, because the housing must be voluntarily accepted by the employee. And again, as we talked about with deductions, it must be primarily for the benefit and convenience of the employee and not for the employer. There must be a written agreement too. So that's for housing. We also have a credit for meals. So if your boss is feeding you on the job and if you're getting those employer provided meals, then again, as I said before, they can't make money off of it. So the credit can't be more than the meal's reasonable costs or that fair market value. And they cannot include profits in that number, okay? And again, they can only get the credit if the employee accepts the meals voluntarily and without any pressure. And then that last category of credits are tips. So we touched on this a little bit, but an employer can take a tip credit of $3.02 per hour to offset your tipped wages. And one thing to keep in mind here is a tipped employee is considered basically, if you make $30 a month or more in in tips, then you're considered a tipped employee. Okay. And if you are not getting minimum wage, then your employer is going to have to make up the difference. So that's something, again, to kind of keep your eyes on and really look at the breakdown of your pay to make sure that you're making minimum wage for every hour. Again, if not, your employer has to make it up. Okay, next slide. Great. So another, I think, helpful tip, another, thing that you can put in your tool belt to make sure that you are, really looking at your paychecks and getting the info you need. It's always a good idea to check your pay stubs. So look at your total wages, so before deductions, look at the paycheck amount after deductions, make sure it's for the correct pay period, make sure that all the deductions are listed and that they explain what they are. You want to make sure that it has your name and social security number and your employer name and address. So you want to have all that information. And again, as I said, this is just another tool in your tool belt to really combat wage theft. Next slide. All right, so I get this question a lot too. Should I be making overtime? Next slide. So who qualifies for overtime? And this is a tough one. Not everyone does. So not every worker in Colorado is going to be entitled to overtime. But the good news is that most employees in Colorado do. The key here, though, is that most employees in Colorado do. That means that if you have been classified as an independent contractor, you might not be entitled to overtime. And that's also why employers like to tell you that you're an independent contractor when you really might be an employee. We're going to talk about misclassification more in a second, but I just want to flag that so that you can start thinking about it. So what is overtime? I think most of us know time and a half. So overtime means that employers must pay you 1.5 times your regular rate of pay. And in Colorado, you're entitled to that overtime if you've worked more than 40 hours in a work week. So that's one scenario, 40 hours in a work week, more than 12 hours in a work day, or 12 consecutive hours. So there's 3 scenarios that are going to entitle you to overtime. So kind of key, I know it's kind of sometimes fuzzy with hours, but make sure that if you've worked more than 40 hours in a work week, more than 12 hours in a work day, or 12 consecutive hours, that you're getting paid overtime. Something else that I wanted to mention, hours in 2 or more weeks can't be averaged out when you're calculating overtime. So the way that this presents itself is, I remember I had a job where if one week I worked 40 hours, the next week my boss would tell me, come in late or, leave early so that you can have that flex time, that comp time. That is not necessarily allowed. So if that's something that your employer is asking you to do, that should be kind of a little bit of a red flag because you're not really allowed to do that comp time, structure. Next slide. Okay, so we touched on this, plenty already, but I'll just go through it real quick. This scenario, I never make any money when the restaurant is slow. Is that normal? And the answer is no. Next slide. So as I described before, we have tipped minimum wage. So that basically means that an employer can take what the minimum wage is and subtract $3.02. So for 2022, in Denver, the tipped minimum wage is $12.85. And for the rest of Colorado, it's going to be $9.54. So you want to ask yourself, am I a tipped employee? So the way that we evaluate that is, do you make more than $30 a month in tips? If you do, then you're a tipped employee, okay? And as I said before, if it is a slow day and you haven't seen a single customer, for example, your boss has to make up the difference in that minimum wage, right? So they have to bring you up to that minimum wage. Another thing that I want to flag here is that, let's say that you work at a restaurant where they charge a 20% service charge or something like that. That service charge cannot be used to fund employee wages. So that's not going to be a workaround for employers to be able to use. Another thing, and this is something that I think is not as known, but employers cannot make tipped employees share tips with non-tipped employees. So if you are a tipped employee and you're being made to share with, managers and maybe back of the house employees, like that might not be okay. Of course, there's exceptions and there's rules around all of this. But if you do think that you've experienced some injustice in this case, reach out to us so we can kind of figure out those details and see if you are entitled to more money than you've been given based on your tipped minimum wage. Next slide. Next scenario, another huge component of wage theft. So my boss gives me a 1099, not a W-2 at the end of the year. Is that right? And unfortunately, maybe not. And it is the most frustrating answer, but the answer really is that it depends. Next slide. So this is the issue of misclassification that we alluded to before. So employee misclassification basically means the practice of labeling workers as independent contractors versus employees, right? This is bad because workers who are misclassified as independent contractors often work without the legal protections typically afforded to employees, such as wage and hour laws, overtime, workers' compensation, things like that. So you're not as protected. And as I said, misclassification is another really large source of wage theft in Colorado. So one example that I saw that was, pretty terrible. Let's say that you're on the first day of your job, you're doing all of the hiring paperwork, and you see a document that says, I, Natasha Viteri, and I am an independent contractor, not an employee, and you're signing that, acknowledging that that's the case. I've seen this happen before. Employers think that this is something that they can do that will prevent them from any kind of liability, but that's definitely not the case. You do need to know what you're signing, but at the end of the day, the issue with this is that you can't really contract around the truth. And the good thing is that if you're dealing with a misclassification issue like this, you can go to the Colorado Department of Labor, and they have a system to be able to kind of figure out, based on the facts of your work, based on how you interact with your employer, whether or not you're an independent contractor or an employee. So there is a solution for you if you think that you are being misclassified. And the trouble with this too is that sometimes this is really hard to notice. It's very hard to spot because each of these issues are going to be very fact specific. So we're going to have to look at the entirety of your situation to kind of figure out if you've been misclassified. And some of the things that, if you do go to the Department of Labor, some of the things they might look at is how much control your boss has over you. Do they tell you how to do everything? Do you typically engage in that kind of independent profession yourself? So there's a lot of questions that will be asked to kind of figure this out. But as I said, it's very kind of, fact specific, and every case is going to be a little bit different. But again, kind of keep this in mind, look to see, were you paid with a 1099, were you paid with a W-2, and do you have your own business where you're doing this kind of work, or are you an employee? So again, think about these things. And this might be a way to get, money back and to be classified correctly and get those protections that you should be entitled to. Next slide. All right, so I just want to go through some additional examples here, just really quick, because these are just common questions as well. So these are scenarios that present themselves in different types of industries. So for example, people often will ask about sleep time. So what is sleep time? It's what it sounds like, right? It means time in which an employee may sleep, which can be compensable. So depending on the situation, you might be compensated for that sleep. So if your shift is 24 hours or longer, up to 8 of those hours can be excluded from overtime compensation. In order to exclude those hours from being paid as overtime, there are certain requirements. So one, for example, there must be an express agreement between the employer and the employee, all right? Your employer must provide adequate sleeping facilities for an uninterrupted nights of sleep. So if they're not going to deduct it, they have to give you a good place to sleep. At least 5 of those hours of sleep you must be able to sleep at least 5 hours of sleep during that time to be able to be classified in that way. And you shouldn't be interrupted. either. So if you're being interrupted again, that might be actual work time instead of that, that kind of sleep time. However, and the difference here is if your shift is less than 24 hours, then, and if you're required to be on duty, then you're going to be paid. So sleep time's a little strange, but if you are facing, that kind of problem, or if you think you're not being compensated correctly, fill out an intake form and we can help you figure it out. Okay, these other three, so donning and doffing, which basically means, putting on and taking off, uniforms. So let's say that you're a nurse and you have to put on PPE, right? Or let's say that you work at a poultry farm and you have to put on the gear to be able to work on the line. So if you spend more than 1 minute doing that kind of activity, then you should be paid. And the same thing is going to go for wait time and health screenings. So let's say that you're waiting to be assigned tasks, or maybe you work for Amazon and during the height of the pandemic, they were testing, employee temperatures, and there were long lines outside before every shift. That time waiting should also be compensable because, again, you are basically on duty, you're working, and you're not able to do your own thing. So those kinds of things should also be compensated. Next, please. All right, so how do we address wage theft? So what kinds of things can we do? We talked a little bit about, making sure you have the information, making sure you write things down. I also want to highlight something that I briefly mentioned before, which is the Colorado Department of Labor and Employment. They address wage theft through an adjudication process, which basically means that you can file a complaint with the Department of Labor and they'll investigate your claim and then will tell you how much you're owed, if there's penalties. So that's a good way of going about it. And it seems to be a pretty accessible process. And what I also like is that they have bilingual compliance investigators. So if you go and you speak, and if you're monolingual Spanish speaker, you can get someone to help you in your own language as well. If you decide that you don't want to use the Department of Labor, you can also go to the private sector. So you can hire an attorney to help you with that. They might write a demand letter. They might help you with the CDLE process. Lots of different things like that. Next slide. All right. So I want to come back to the timeline here just to kind of figure out where we are. And as we talked about before, we addressed different ways that that you can address wage theft once you're an employee. So once you've already been underpaid, what can you do? But really, one of the best ways to address wage thefts is to prevent it. So you want to make sure that you get in front of it and that you know what your rights are from the beginning. If we know how much we should be making, and if we really understand all of the terms of our employment, then we'll be able to detect this much quicker before it becomes a bigger problem. Next slide. So I've got more tips for you. So lots of lists tonight. But I really, you really should have the information. So before you start a job, you want to make sure that you know your employer's full name, what the company is called, the company address and phone number, who's responsible for paying you, who's in payroll, who's supposed to be cutting you the check, right? And for payment information, this one you want to make sure you have in writing. So how much will you be paid? Are you going to be paid by the hour, by the piece, by, in a salary? How often will you be paid? Is it monthly? Is it every 2 weeks? Is it every week? Is it by project? And how will your wages be calculated? Are you making minimum wage? Are you making more? Are there bonuses? Is it commission? And who will pay you? Again, if you have all this information in writing, it's going to be so much easier for you to go and start a process with the Department of Labor or hire an attorney to help you recover your wages. Next slide. So we're back to our timeline again. So we discussed how we can be proactive about wage theft. And we want to think about that even before we start our first day of work. But now let's talk about other common scenarios that present themselves during our time as employees. So we're going to talk about discrimination next. Next. Great. So another question or scenario that we get pretty often, my boss treats me differently from my coworkers. And of course, this can mean a lot of things. Next. All right, so employers in Colorado cannot discriminate against you based on a protected class. So what is a protected class? There's a lot of them, and I'll just run through these, a little bit quickly. But an example of a protected class, for example, is a disability. And this can be mental or physical impairment, which substantially limits a major life activity. There's also race. And in Colorado, that's going to include hair texture, hair type. If you have a protective hairstyle, commonly or historically associated with a race. So if you have braids, locks, twists, afros, head wraps, all of those are going to be protected too. You have things like creed or color, sex, sexual orientation, gender identity, gender expression, religion, age, but really they focus on if you're 40 and above. So that's a little bit tricky with age. There's national origin, ancestry, and then pregnancy, childbirth, and related conditions to that. And on top of protecting based on discrimination of a protected class, employees who have engaged in protected activity. So let's say that you made a complaint of discrimination, or let's say that you have a disability and you're requesting an accommodation. Those actions are going to also be protected from retaliation. So if your boss retaliates you or demotes you or fires you or does anything negative against you for speaking out or for requesting an accommodation, that's going to be illegal too. One thing to keep in mind though in Colorado is that if you are an individual that's engaged in domestic service, so if you're a personal nanny or a housekeeper, or if you're an independent contractor, you might not be covered by the Colorado Anti-Discrimination Act. So that's something to keep in mind as well. Next slide. So what is employment discrimination? What counts? What does that mean? Essentially, it's discriminatory and it's illegal for an employer to refuse to hire you, to fire you, to refuse to promote you, to demote you, to harass you during the course of employment, to discriminate even matters of compensation. So if you're a woman being paid less, even though there's men in your same position that are making more, to discriminate in the terms, conditions, or the privileges of your employment. And if they do that based on your protected class, again, that's wrong. As I said before, if they retaliate, that's also going to be something that's not allowed. And in addition to all of that, employers have a duty to provide reasonable accommodations that may be necessary because of an employer, of an applicant's or an employee's. So this attaches before employment too, if you're applying for a job. So if they discriminate or if they do not provide accommodations based on pregnancy or disability, then that could also be something that they can get in trouble for. Okay, next slide. So who do you call if you run into these issues? There's two places that you want to kind of start with. So there's the state version and the federal version. So if you're looking at the state version, you want to go to the Colorado Civil Rights Division, which is known as CCRD. And that's going to cover any Colorado employee, as I said, except independent contractors and people in domestic service. So for CCRD, you have 6 months from the incident or from that instance of discrimination to be able to file a complaint. The federal version, which is the Equal Employment Opportunity Commission, also known as EEOC, that one is going to cover most employers with at least 15 employees. It must be 20 employees if you're talking about an age discrimination claim. And for the EEOC, the filing deadline is going to be 180 days. However, that filing deadline can increase to 300 days if the charge also is covered by a state or local anti-discrimination law. The important thing here is that if you do feel like you've suffered from discrimination at the workplace, you want to file earlier than later because these filing deadlines are a little bit tight. The good news is that if you file or submit a complaint with the CCRD, you can dual file and send the complaint to the EEOC as well. Next slide. Okay, so another scenario that we often hear is, I feel like my boss is always criticizing my work and putting me down and they bully me at work. Is that illegal? So that's a great question, and we're going to kind of go through the nuances of what that would mean and when you're entitled to some sort of relief. Next slide. So this is going to be known as harassment, right? You know, we've all maybe experienced harassment at work in one form or another, but basically harassment is unwelcome conduct that is based on race, color, religion, sex. So those protected classes, right? It's not illegal for a supervisor to harass an employee because they don't like an employee's work. So if they don't like you as a person, that might not be illegal. But if they're harassing you based on a protected class, then that's different. In addition, we want to keep in mind that harassment becomes unlawful, so it becomes illegal, when kind of withstanding or enduring or taking that harassment is basically a condition of continued employment. So for you to keep working here, you have to put up with this bad treatment, right? If the conduct or the harassment is severe and pervasive enough to create a work environment that a reasonable person would consider to be intimidating or hostile or abusive, then that can also kind of go up to that level of being unlawful. Examples of what would kind of count. So for example, offensive conduct may include, but is not really limited to, offensive jokes or slurs, name calling, physical assaults or threats, intimidation, mockery, insults, offensive objects or pictures, and anything really that's going to interfere with your work performance. Unfortunately, unless an isolated incident is really extremely serious, one event won't kind of rise to the level of unlawful. It has to be more of a pattern. So yeah, that's harassment. So kind of keep in mind what that line is. It's a little bit difficult. But now let's talk about sexual harassment. Next slide. Okay, so what you want to know about this is that both state and federal law prohibit unwelcome sexual conduct when it affects an individual's employment, when it interferes with their work performance, or just like in the harassment context, if it creates this kind of intimidating, hostile, or offensive work environment, right? So it is unlawful, it's illegal to harass a person based on that person's sex. And harassment can include sexual harassment or unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. However, it doesn't have to be of a sexual nature. So harassment can include offensive remarks about a person's sex. So for example, it is illegal to harass a woman by making offensive comments about women in general, right? Great, next. Awesome, so now that we've talked about wage theft and discrimination, we want to go back to our timeline. So whether you're leaving your job because maybe your wage theft issues weren't resolved, or you've experienced discrimination at work, or you simply want to change of pace, you might encounter different obstacles when you're trying to quit or when you're trying to leave your place of work. Next slide. Okay, so we also hear this one a lot. So in this scenario, a worker feels trapped in their job. So what can they do? What kind of solutions are there? What's allowed by law and what's not? So you might feel pressured as an employee to stay in your job because of lots of different factors. So maybe you signed an agreement saying that you'll have to pay back an immense amount of money if you leave, right? Maybe you're being forced to work by threats of violence. Maybe your employer took your passport so that you actually can't physically leave. So regardless, let's review some of the tactics that employers typically use to get you to stay, whether you like it or not. And let's talk about what you can do about it. Next slide. So when we think about trafficking, we think kind of about this image, people in chains, people being forced to work with a gun to their head, things like that. However, labor trafficking and forced labor can look a lot of different ways. And basically, labor trafficking is a modern day form of slavery in which individuals perform labor or services through the use of maybe force, coercion, pressure, fraud. So they're being forced into doing these things. Labor traffickers use lots of tools. So they use acts of violence, they use lots of threats. It might be an immigration threat. They might, tell you a lot of lies, or they might use other forms of coercion to force people to work against their will. And this happens across lots of different industries. So some examples. So what can this look like? Because this looks a lot of different ways. So for example, people that are forced to work as domestic servants and are not allowed to leave are being charged for the food they eat or for staying, with the family that they're helping. A lot of those situations can lead to forced labor where these domestic servants don't feel like they can leave. Another example can be for factory workers held in really inhumane conditions with little or no pay. Maybe they're having their wages withheld, so they have to stay in order to see their wages, and if they leave, they don't get them. You could also be, for example, we've had cases where we've dealt with nurses that are trapped by really just terrible contracts. So these contracts will have a clause or a part of the contract that says, we're giving you this job, where they're promising all of this money and all of these great benefits, but then when they start working, they realize that if they leave, they're going to have to pay $20,000, $30,000 to be able to leave their position because they have to, pay for a placement or pay for all these benefits that they really didn't receive. So these threats of financial ruin are kind of known as debt bondage. So that's something to keep in mind too. If your contract just has a clause like that just seems a little fishy, that could be a form of forced labor as well. Other examples include people in detention that are forced to work, and they kind of are forced to work under these threats of punishment or being sent to solitary or things like that. That's also going to be forced labor. And then we also have examples, for example, foreign guest workers that are exploited by a visa system. An example of that are sheep herders in the West. They're promised this great job sheep herding in the mountains in Colorado, but are treated terribly or not given food. Their passports are taken away and they are paid just less than they were promised. So that's another form of forced labor. Next slide. Okay, so if you find yourself in a situation where you feel like you've been trafficked or you feel that you've been subjected to forced labor, there are certain protections for you as well. And I wanted to flag the TVPA, which is the Trafficking Victims Protection Act. So this act was enacted in the year 2000, and it establishes methods for prosecuting traffickers, for preventing human trafficking, and for protecting victims and survivors. And something that might be more interesting about this is that if you have been trafficked, there might be restitution for you as a victim, and there might be some immigration relief through a T visa. Now, the thing about this, so a T visa will grant you some sort of status, but I do want to flag that I recently spoke to an immigration attorney, and it seems like the wait list for a T visa right now is around 10 years. So I bring this up because if you do feel like you have been trafficked in the labor context, then you want to make sure that you start that process earlier rather than later, just because of how extensive those wait lists are. Next slide. All right, so we're almost done. I just want to flag a few more things and other tools that employers will use to keep workers trapped in their jobs. So I wanted to talk about this because we really do care about a worker's right to leave their jobs and to seek employment elsewhere, because we believe that that's essential to worker dignity and their bargaining power. So if you are able to leave a job and ask for more money, or kind of leverage your experience to get a higher wage, then that brings wages up. If they are able to keep you in a job that you don't want to be at, and if they don't pay you well, then that depresses wages. So for us, this is a huge issue that kind of affects wage and hour law as well. And employers frequently use lots of different types of illegal and unenforceable contracts to again keep workers kind of stuck in their jobs. So some of these contracts will prevent workers from looking for other jobs or leaving their employment. So that would be more of like a non-competition, a non-compete agreement. Other times, like we talked about with the nurses, sometimes employers will make workers pay money to leave their jobs. So that can be called a liquidated damage provision. And sometimes employers will agree with each other to not hire each other's workers and to not pay damages for doing so. And that would be more like a no poach or no hire agreement. So again, these arrangements are meant to suppress pay, and they're meant to keep workers trapped in often unsafe and really abusive work environments. Next slide. Okay, so I wanted to focus on non-competes for a second, just because in Colorado, Colorado's moving to make these a little bit more unenforceable. So let's take a closer look at non-compete agreements. These are really common in today's employment contracts. And your employer may have had you sign one of these without you realizing. It might have been, in your new hire paperwork or things like that. However, in Colorado, if a non-compete agreement is way too harsh, or if it's way too unfair to the employee, so if it's setting like a really unrealistic amount of time before you can find another employer in that field, then it can get nullified. So you can cancel it if it kind of reaches that level. So in Colorado, non-compete agreements are not allowed generally unless they fall into certain categories. So one, if your employer is using that non-compete to recover the expense of employee education, so if they provided you education. Two, if it's going to kind of, restrict the movement of executive and management personnel. So those are going to be for higher level jobs within a company or things like that. If they want to use this agreement to protect trade secrets, or if they want to protect the purchaser. So those kinds of conditions might be able to make a non-compete agreement okay, but just know in general, they're not really allowed. In addition, one more thing to flag about non-competes is that an employer may be in the wrong and may be acting illegally if they threaten you. So if they use threats, force, or other, kind of forms of intimidation to prevent you from, leaving or, things like that, then that could also invalidate a non-compete agreement that would have otherwise been okay. So something to keep in mind about, those non-competes if you do encounter one. Next slide. All right, I forgot that was the last slide. So that's all I have. I have not been keeping track of the chat, so if there's any questions, let me know, but I know that was a lot of information to process.
Okay, we've come to the end of it. Jennifer, if you'd like to join us to see if there's any final questions before we close out for the evening. And thank you so much, Natasha. We do have a question.
Pleasure, of course. Yeah.
Jennifer, would you prefer to appear on video so you can ask the question directly, or do you want to relay it to me through the chat? I believe the question is from one of our live participants at the CMC campus.
Can you hear me okay?
We can hear you.
Okay, if I could have someone who is here ask a question. She doesn't feel comfortable putting it in the chat, but she could over the video, if that's okay.
Yeah, of course. The only issue is that we are recording. We could end the recording now so that she can appear on screen.
Yes, let's do that, please.
Okay, well, we're going to go ahead and end the recording now. Thank you, everybody, for joining us. Natasha, before we close the recording, could you remind people where they can reach you for any questions?
Of course, yes. Apologies, that was in the last slide. But if you go to our website, towardsjustice.org, and if you go to get help, you can submit an intake form and we'll be able to help. If not, I'm also happy to put my email in the chat if that is what we want to do.
Thank you. And at this point, we will stop recording. Thank you so much to Dea, our interpreter. You are relieved of duty.